From a man charged with assault with a deadly weapon and violating a protective order.
Based upon what you're charged with, which is ag assault with a deadly weapon and violation of bond or protective order, assault stalking, I need to hear from the complainant because.
To another being sentenced to a year in jail for theft.
So do you want to spend the rest of your life in prison? Then you need to stop stealing. You understand?
Here are 4 moments where Judge Boyd ensures accountability and justice. Starting with Mr. Gonzalez, who was charged with felony assault after dragging his ex-girlfriend and violating a protective order. Now he wants the no-contact order to be lifted. Let's see how that works out for him.
Gonzalez. All right, Emanuel Gonzalez, if you'll come forward. Good morning. Thank you for dressing appropriately for court. All righty. So where are we on this case?
Judge, this is the first setting. There is an offer, but there's a lot of evidence that I need to review with my client.
Okay. So state, is all of the discovery up?
Yes, to my knowledge, Your Honor.
All right, Ms. Ferguson, how old are you, sir?
42.
All right, Ms. Ferguson, if you'll set this in 30 days for a plea deadline date, please. All right, June 9th, is that good for you?
Yes.
I know school is about to start being out, so. All right, so we'll be back on June 9th. On June 9th, you'll need to let the court know whether or not you've accepted the state's agreement or you've reached an agreement. If you have not reached an agreement, your next court date is going to be a jury trial, okay?
Judge, if we could approach on the no contact order.
Sure. Just 1 second, let me put this in. And the no contact order is with,
Ms. Scott, the complainant in the case.
all right, I'll hear both parties.
Defense submission, I'll just rebut.
All right.
Judge, in speaking with the state, it's my understanding that I guess they've talked to the complainant. She doesn't oppose removing the no contact and making it a no harmful injury contact. This is an offense date of 2023. There was a protective order since that time. I believe in 24, the protective order expired. And since that time, he was having visitations with his daughter. The primary issue is not contacting the complainant. It's able to see his daughter.
Can't they do that through a third party? Usually they're grandparents. What I tell you is I don't normally lift no contact orders without speaking with the complainant. And if it's just a child custody issue, usually they're grandparents who can be the third party.
My dad's deceased and my mom's elderly.
All right. And what about the maternal grandparent?
Parents really don't talk to me. I could try to get my sister to talk to her, but I wanted to ask you if that was okay. I didn't know if that was okay or.
Oh, you can have your sister and his sister, unless there's some issue from the state.
Not that I'm aware of, Your Honor. Specifically with this case, the state's concerns is that there are prior assaults with this victim. Those cases, although the defendant has not been convicted of them, they have arisen and they are in his criminal history with this particular victim. And as the court knows, the state just likes to make sure that the victim is protected in these types of cases. As far as the no contact order and child custody, as long as they're going through a third party and there's no contact between them, I don't have any objection to that.
All right. And have you had contact with the complainant? Is she saying she wants to have contact?
We have, Your Honor, and she has said that she is okay with the no contact order being changed to no harmful or injurious contact order. However, the injuries and the facts of this case are pretty gruesome. The victim was dragged for quite some time.
Well, no. I'm trying to figure out if she said that okay. So you're going to have to do that through a third party. So if your sister and the complainant has no objections to that, then it can be done through a third party. But I don't lift normally no contact orders unless the complainant is present.
A lot of the allegations that she's talking about.
No. Here's the thing.
Charges.
No.
That were charged.
Fine. So let me just tell you, number one, usually your attorney doesn't want you speaking about the facts of this case or other cases because that could come up. Here's the thing, it could still come up, right?
Because she mentioned that I had other cases prior to
Here's
that,
the thing, if the statute of limitations has not ran, it can still come back up. So I don't think your attorney wants you speaking about that, but I want you to hear me clearly. Regardless of what argument your attorney makes, what argument the state makes. Let me just tell you, the state could say right now, we're in agreement to no harmful or injurious contact. And you know what I'm going to say? Based upon what you're charged with, which is ag assault with a deadly weapon and violation of bond or protective order, assault stalking, I need to hear from the complainant because the state says, oh, we need to make sure the community is safe. but that is part of my job too. I'm a gatekeeper. When I put conditions, I have to make sure that those conditions, if somebody's on probation, it rehabilitates them, but also protects the community. When people are on bond, the conditions I set supposed to help them to be successful while they're on bond, awaiting to answer to the charges, and also to protect the community. So based upon what you're charged with alone and what I'm reading in the indictment, because I don't get a police report, I'm not going to allow you to have contact with her. So if it's the issue of a child, then that needs to be done through a third party. I don't even know why Child Protective Services is not involved, because they should be involved because of what the charges are. Usually when there's a mother and a father, when there's a mother and there's a father, and there's an aggravated assault with a deadly weapon in violation of protective order, stalking, CPS should automatically be involved. I don't know why they're not involved. Guess what? Part of my job is not being a civil judge. So they need to handle that on the civil side. The reason why I tell you this is to let you know, I am not going to agree to sign an order that says no harmful or injurious contact without speaking to the complainant. So it doesn't matter what the state's argument is. If the state says they want you to have contact with her, as long as it's not harmful, I'm going to tell them the same thing. I am not going to lift it without the complainant telling me that's what she wants. And even then, I may still not lift it based upon the charges that are before me. Okay? All right. So we'll be back on June 9th. Once you sign the reset form, you are excused. Thank you.
Thank you.
This time, we have Mr. Cross charged with felony obstruction, retaliation after a psychotic episode led to criminal behavior. Now his attorney is fighting for probation. Let's see how the judge handles this.
All right, the court is calling 2025 CR 004894 State versus Jack Daniel Cross. Could I have parties announce?
Andrew Harrison of the state.
Alfonso Otero on behalf of Mr. Cross. Good morning, Judge.
Good morning. And is there going to be any applications?
Yes, Judge.
Yes.
All right, are you, probation, this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Cross, did you review the document entitled Application for Deferred Adjudication?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Good day, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? All right, you're gonna have to speak up.
Yes, ma'am.
Did you understand you're charged with obstruction or retaliation as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to enter into a plea in this case and give up those rights?
I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Good day, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Cross, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea bargain agreement, the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged, how do you plead?
No contest.
State any evidence.
It offers exhibit 1 and attachments.
No objection, Judge.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there's sufficient evidence to find the defendant guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, just follow the plea bargain.
All right, so Mr. Cross, I see that you were taken to the hospital. Have you received a diagnosis or no?
Yeah, for schizophrenia.
All right, so are you currently on your medications at the jail?
Yes, ma'am.
All right, and there's no issue you believe with competency or sanity at the time of the offense?
No, Judge.
All right, if you're released, do you have a place to stay?
Yes, ma'am.
Would you be staying with someone?
Yeah, my mother.
And are there any minors in the home, any children?
Oh, nice.
All right, so what do you spend your time doing?
I try to occupy my time with playing video games.
Okay. Have you ever been employed or did you receive SSI?
So I'm currently unemployed.
All right. When's the last time you had employment?
So I try to work at various different jobs doing like tedious things.
Okay. Did you finish school?
No, ma'am.
How far did you go in school?
I made it to 9th grade.
And why did you drop out?
It's just I just was had a lot of stress going to school, so I decided to not further my education.
All right. Do you have any children?
No, I don't.
All right. So this is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. Does your client have any criminal history?
No, that I'm aware, Judge.
So I did receive a failure, or it's gonna be silent or abusive phone call to emergency services in Midland County. I forgot what county. it was.
All right. So this is what I'll do. Instead of the 4 years deferred adjudication, I'm going to do 5 years deferred adjudication. But if he completes everything successfully, he can come back and ask for early termination. So 5 years deferred adjudication. Probation, how long is the MIC evaluation in custody?
And then depending on that, he needs to follow with, they need to follow consent for that.
And I'm going to tell you, here's my fear. You obviously need to be on medication. During this episode, it's clear to the court that he wasn't on medication. So I can do one or two things. One, I can have him remain in custody and wait for the MIC evaluation. Is the time the same in and out of custody or no? How much longer out of custody? Sure. Okay. Please. Yes, June 9th. All right. So what we'll do is I'll do sentencing on June 9th, but they may be able to have it done before then, okay? Here's the reason why I'm doing this. Based upon what I'm reading in the police report, I don't want to set him up for failure. I want to make sure that he has a case manager, that he has his medications to take. Otherwise, that's not going to happen. And you're going to end up right back here. And because this is a deferred adjudication, you're looking at potentially 10 years in prison, and I don't want that to happen, okay? So I'm going to set it for June 9th, but they'll probably have it done before June 9th. And then as soon as it's done, we will take it up, definitely at the latest, June 9th, but it'll be before then.
Your Honor, I had a question.
Sure.
Would you take into consideration my back time? Because I've already been in custody for almost 90 days, more than like 100.
All right, that's something that's completely separate from this plea.
Oh, okay.
Yeah. Usually taking in consideration time has more to do when someone decides they want to do a prison sentence. Yeah. So we're going to try to get it done as quickly as possible. I'm sorry we can't get it done any sooner. This is done through third parties. It's not done through me, okay? So at the latest, June 9th. at the latest. But the probation officer has your attorney's contact information. So if we have it before then, we'll bring you in before then. And defense, if for some reason you're out of county, you can always zoom in and we'll get it done that way. All right, thank you.
Great, Judge.
Unlike the others, this one centers on Mr. Harris, who is on probation for stealing a car and admitting to drug use back in court for bond.
Right. We're going to go on the record. The court is going to call 2025 PF 03497 and 2025 PF 03496. Could I have parties announced for the record?
Megan Galloway for the state.
And Kelly Piddle for Joseph Harris.
All right, and you're Mr. Harris?
Yes, Your Honor.
Do you have any objection to your attorney appearing by Zoom?
No, ma'am.
State any objections.
No, Judge.
All right, the defense has filed a motion to set bond in each of these cases. State, are you prepared to proceed on the motions?
Yes, Your Honor.
And the court sees that there's a proposed agreement for $20,000 in each bond. Is that, in each case, is that correct?
Yes, it is, Your Honor.
All right. So other than these two cases, does the defendant have any other criminal history?
He's currently on probation for the offense of unauthorized use of a motor vehicle. We had a contested MTR set last week in which the state withdrew the MTR and the court put him on partial GPS.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Joseph Harris, Your Honor.
All right, have you ever used any type of drugs in the past?
Yes, Your
Judge,
Honor.
I'm gonna advise him not to answer that question.
Then what I can tell you is I can't set bond because I need to set conditions of bond so that he can be rehabilitated. So if he has drug use in the past, I need to know, because I need to know whether or not to have him do random UAs. Otherwise, if you don't want me to ask any of these questions, I'm going to load his conditions up with everything that he could possibly need help with.
Judge, he's being supervised by probation and providing UAs to probation. I would ask that.
I'm going to add it to his conditions because the problem is the motion to revoke was withdrawn. So if you all want me to fly blind, I will fly blind, but I can tell you what's going to end up happening. He's going to be loaded up with every type of condition because the law says that I need to know certain things about your client and it set certain conditions of bond. So that's where we are. So if you don't want me to ask any questions of that, then I won't ask any questions of that. But he's going to be loaded up with all the conditions of bond as though these are issues he may have.
Judge, please proceed.
Proceed with questions or proceed with
Yeah.
conditions?
Questions, please.
All right, so have you ever used any type of drugs in the past?
Yes, Your Honor.
All right, and what type of drugs would those be?
Marijuana.
Anything else?
No, Your Honor.
How far did you go in school?
9th grade, Your Honor.
All right, and have you been previously employed?
Yes, Your Honor.
Doing what?
I work at a cabinet shop.
All right, and then the next question is, if you were released on bond, do you have a place to stay?
Yes, Your Honor.
Who would be in the household?
My girlfriend's dad and her grandma. Your Honor.
All right, are there any minors in the household?
No, Your Honor.
And have you ever had any type of mental health issues?
Yes, Your Honor.
All right, have you ever been diagnosed with any mental health issues?
Yes, Your Honor.
All right, and have you ever taken any medication for that?
Yes, ma'am.
All right, any other questions before the court sets bond?
No, Judge.
All right. And each cause number, this is what the court will do. The court will set your bond at $20,000. The court is going to order regular UAs. There's going to be sober support meetings. There is going to be 90 sober support meetings in 90 days. There's going to be partial GPS, waive fees. And that is for employment only. Do you understand?
Yes, ma'am.
And state, do you want a curfew with the employment?
We would request 9 PM curfew, but if his hours were for, we would.
So with regards to your employment, and I want you to understand what I'm saying, and if you don't understand it, just let me know.
Yes, ma'am.
So while you're on GPS, you're allowed to work. If for some reason your work schedule, let's say your work schedule is from 8 AM to 3 PM. Even though the state is saying they're recommending that with your work schedule, your curfew be till 9 PM, you're not allowed to stay out till 9 PM if your work hours end before then. Do you understand?
Yes, ma'am.
Now, if for some reason your work hours go to 9 PM, then you're allowed to be out at 9 PM because you're at work. If your work hours go to 10 PM, your attorney is going to have to come in and ask for permission. Do you understand?
Yes, Your Honor.
If you deviate from this partial GPS for work only, then I'm going to receive notice, the state is going to receive notice, and there's a potential that your bond could be revoked and a judge's warrant will be issued and you will be taken off a bond. Do you understand?
Yes, ma'am.
So some people think, oh, on my way to work, the Burger King is right there. Let me stop at Burger King. You're not allowed to do that. It's from home to work. You understand?
Yes, ma'am.
All right. And do you have health insurance or no?
No, ma'am.
All right. And are you currently on any type of medication for mental health issues?
Lexapro, Your Honor.
All right. So there's going to be a referral to Center for Healthcare Services. If you have your own personal doctor that you're seeing, then you can see that personal doctor. You understand?
Yes, ma'am.
And is there anything else you need from the court to be successful on your bond?
No, ma'am.
All right. Any other requests from the states?
No, Judge.
So we can go off the record. Here's the thing. They asked that your motion to revoke be withdrawn. When you are released from custody, you need to immediately go to probation. You're probably not going to be released from the Bexar County Jail till midnight. So the next day, even if you're tired, you need to call into your probation officer. Do you understand?
Yes, ma'am.
Is there anything that you do not understand that I'm requesting?
I just have one question.
Sure.
So last time when they put me on the GPS monitor, is that gonna be the same system? It's work release, right?
Yes,
Okay, yes, ma'am.
because I'm asking that the fees be waived.
Yes, ma'am.
So they should be able to get you on a GPS monitor today, but if not, it'll be at the latest tomorrow.
Yes, ma'am.
All right. And probation, I know his motion to revoke was withdrawn, but are there any other things that he needs to know or anything he needs to do once he's released? All right, thank you.
Thank you, Your Honor.
Now, the last case centers on Mr. Hernandez, a repeat offender back in court and facing theft charges. Let's see how Judge Boyd deals with this one.
State versus Joshua Hernandez. Can I have parties announce?
Andrew Harris Sadelman for the state.
Allison, for Mr. Hernandez.
And are you Mr. Hernandez? Counsel, have you received all discovery?
I have.
And did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there any applications here?
No.
All right. Probation, no applications. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yeah.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Hernandez, did you review the court admonishments with your attorney?
Yes, ma'am.
And did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with theft of property with 2 or more previous convictions as a state jail felony?
Yes, ma'am.
That is, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's a $1,000 fine. The state will take in consideration 2025 CR 004540. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no?
No contest.
State any evidence.
Should be contained in Exhibit 1 and attachments.
Without objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you want to say on behalf of your client?
We'd ask that you follow the agreement.
All right, why are you continuing to steal? What's going on in your life? Nothing?
No, ma'am.
So do you want to spend the rest of your life in prison?
No.
Then you need to stop stealing. You understand? The total of these items is $117. So you're about to spend 1 year in the state jail facility. That's day for day time. You have to ask yourself, are those items that you took that total $117 worth a year of your life? Now, if there's an issue where you have a drug issue, if you have a homelessness issue, if you have a food issue, there are plenty of places in San Antonio that will help you with your drug issues, that will help you with your homeless issues, but nobody can help you if you don't want it. Otherwise, what's going to end up happening, you're going to come back here and at some point in time, this is going to be a habitual and you're looking at 2 to 20 years. Do you understand? All right, the court is going to find you guilty, sentence you to 1 year in the state jail facility. There's $1,000 fine. Taking consideration 2025 CR 00450. All right, is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you don't have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Thank you.